The abortion issue has once again taken center stage in the presidential elections and in state ballot measures in Colorado and South Dakota. In Colorado, people are being asked to vote on Amendment 48, the Human Life or Personhood Amendment, that would give full personhood to the unborn from the moment of fertilization. In South Dakota, voters are being asked to vote on Measure 11 that would ban most women who need abortions from having them and, quote, protect the lives of unborn children. You should vote no on Colorado's Amendment 48 and no on South Dakota's Measure 11. Why? Because these ballot measures will not only affect women who want to end their pregnancies, but also pregnant women who want to go to term. How do we know this? We know this from the experiences of women from around the country. Amber Marlowe went to deliver her 7th wanted child in Pennsylvania. The doctor assigned to her decided that her baby was too big and that she needed a C-section. The hospital, relying on the argument that fetuses are legal persons with rights separate from those of the pregnant women, exactly the rights that would be established under Colorado's Amendment 48 and South Dakota's Measure 11, got a court order giving it custody of the fetus before, during, and after delivery, and the right to force Ms. Marlowe to undergo major surgery without her consent. While in active labor, Amber Marlowe fled to another hospital where she delivered a healthy baby naturally. As a result of this experience, the Marlowes, who are profoundly opposed to abortion, nevertheless learned how anti-abortion fetal rights arguments are used to hurt women who want to go to term.
To say that Amendment 48 would endanger cancer patients or criminalize miscarriages or do all the host of other things our opposition claims, those are simply hysterical scare tactics. They're simply not true.
At 27 years old and 25 weeks pregnant, Angela Carter became critically ill. She, her parents, her husband, and her attending physicians all agreed to carry out her wishes and to keep her alive for as long as possible. Nevertheless, the hospital called an emergency hearing to determine the rights of the fetus. The court held that fetal rights outweighed Angela Carter's right to life and ordered cesarean surgery, despite the fact that the surgery could kill her. The surgery was performed. Neither Ms. Carter nor the baby survived. In Florida, Laura Pemberton wanted to have a VBAC, vaginal birth, after having had a previous cesarean surgery. Like many women in the United States, she found that local hospitals would not provide her care unless she agreed to a planned cesarean. She didn't want to undergo another dangerous surgery if she didn't need to, so she stayed home to have her baby. When she was in active labor, she heard a knock on the door. It was a sheriff. He took her into custody, strapped her legs together, and compelled her to go to a hospital where a hearing was being held to determine if she could be forced to have cesarean surgery. Although the state provided a lawyer for the fetus, no lawyer was appointed for Ms. Pemberton. When this woman, who also vehemently opposes abortion, argued that her right to informed medical decision-making, bodily integrity, due process, and liberty had been violated, she was told that fetal rights outweighed hers. She went on to have 3 more children, all naturally, proving the doctors and the court wrong.
Colorado is one of only 13 states that does not have a fetal homicide law. A fetal homicide law basically recognizes that if a pregnant mother is injured and her unborn child is injured too, if you have a fetal homicide law, you can protect that child. It does not criminalize women who have miscarriages.
In Utah, Melissa Rowland gave birth to twins, one of whom was stillborn. She was arrested on murder charges based on the claim that by refusing cesarean surgery 2 weeks earlier, she was responsible for the stillbirth. When asked what legal authority the state had for treating a stillbirth as murder, a spokesman for the Salt Lake County District Attorney's Office explained that the charge was required by, quote, Utah's feticide law, which was amended in 2002 to protect the fetus from the moment of conception.
I wish my baby was born sitting on.
These are real experiences, not hysterical scare tactics. That's why people need to vote no on Amendment 48, no on Measure 11. Voters need to remember that opposing the recognition of fetal rights as a matter of law is not to deny the value of potential life as a matter of religious belief, emotional conviction, or personal experience. Rather, it is to support a real culture of life, one that includes and values the women who give that life.